And I, Sumit, Director for Center for Computational and Economics, would be moderating the panel discussion. This conversation happens in the backdrop of a couple of crucial developments happening across the globe. Most importantly, being a three-part report which has been done by the US Copyright Office. Now, this three-part report, this report is in three parts. The first part looks into the question of digital replicas and whether the existing US copyright law is sufficient enough to address the question of violation, the question of harms associated with these digital replicas as they stand due to the advent of artificial intelligence. The second report talks about the output aspects in terms of the output which we sort of get out of artificial intelligence generated content, whether the owner or creator of it could sort of file a copyright claim for such generative AI output. The third and the last report talks about the input aspects, which specifically discusses that the data sets, the inputs which the generative AI companies use to basically train their chatbots, used to train their machines and servers, right? Whether there is a case of violation of copyright law, if there is a prima facie case of violation of copyright law, whether it is covered under fair use or not. If it is not covered under fair use, what could be the possible remedies given the discourse on artificial intelligence as a whole? So now, this being the background, of course, there are some developments on the Indian side as well. There is a case pending before the Delhi High Court between OpenAI and ANI, looking into this specific concern whether the data which is used for training chatbots is in violation of copyright law. The Indian government has also formed a panel under the DPIIT, which is Department of Promotion for Industry and Internal Trade, which would be sort of publishing a report on this specific aspect. With this background, I would invite Robert to sort of shed some light on these three reports, and how this sort of issue is shaping up, and how the governments and copyright offices across the globe should address this question, because the advent of AI is not only there in the US, but I think it is applicable across the globe, including the two most the two jurisdictions hand, which is US and India. Over to you, Robert. Robert, you're on mute.
Thanks, Sumit, and thanks for inviting me to participate in this discussion. So yeah, I mean, I think probably what we're primarily focused on in this panel is the subject matter of the third report. The second one, I think, is has some interest as well. And the Copyright Office has taken a pretty narrow position as to when outputs of generative AI systems will be protected by copyright. They've said that if a generative AI system produces an output of a type that would be copyrightable if it were produced by a human being, but if it's done without human intervention, then there will be no copyright, right? Copyright requires human authorship. And even if a human is involved, in the way that we most often use generative AI these days. So I want an image of a beautiful tree in a garden, and I prompt a generative AI tool, please produce an image for me of a beautiful tree in a garden. The Copyright Office says that's not enough human authorship. That's sort of equivalent to giving the generative AI tool an idea, and the tool itself is filling in what amounts to the expressive choices that a human author would make. How big do we make the tree? Where do we put it in the image? What's the garden look like? All of that. What's the lighting look like? And since the human author is not contributing those expressive components, the output there is not copyrightable either. And I think it's left open to a certain extent just how much human input is needed before the Copyright Office will say, okay, that's enough for human authorship. So There's currently a case pending in which a a graphic artist by the name of Jason Allen is challenging the Copyright Office in court for their refusal of his attempt to register copyright in an image that he produced using a generative AI tool. And so we will see that litigation play out over the coming year or so. And that may give a little bit more um, conclusion on that issue. Now, the third report, right? That was issued this past May 9th in a so-called pre-publication version, just the day before President Trump purported to fire the head of the Copyright Office. So it's kind of a dramatic entry. Um, that report has four substantive parts. The first part just describes how generative AI systems work as a technical matter, since we need that technical background to understand the copyright implications. The second part identifies how copying of works in the copyright sense may occur in the process of training and deployment of those systems. The third part, which is the longest, investigates whether the training of AI systems may or may not qualify for the fair use exception under Section 107. And then, as you said, the fourth part investigates approaches to licensing for AI training purposes, including both voluntary licensing and also various types of compulsory licensing that might be involved. So, and I'm aware that, of course, India doesn't have a fair use exception as such, like the UK. It has a fair dealing exception that lists narrower purposes. But of course, I'm also aware that concepts like transformativeness, which have become important in US fair use law, have a role to play in Indian law as well. That you have the interesting 2011 Delhi High Court precedent in University of Cambridge versus B.D. Bhandari. And you also have the currently pending use that you mentioned of ANI versus OpenAI. So what does the report say about fair use? I'd say that generally, the Copyright Office's conclusions are more favorable to copyright holders than they are to generative AI developers. Um, the report was produced, all of these reports were produced by first issuing a notice of inquiry and soliciting comments from the public. The Copyright Office received over 10,000 comments. Now, some of those were probably just copy and paste comments like, I agree with what that person says, but some of them were more detailed. And so the Copyright Office does take care to report a lot of the substantive comments that were made. And some of those substantive comments were made very much in favor of fair use for generative AI training purposes. But in terms of, and so it reports those comments, but I'd say that it often comes to somewhat more copyright holder friendly conclusions. So as to transformativeness, right? It says, well, if the purpose of this training is to eventually generate outputs of the same type that might compete with the works under copyright that are used for training the models, it says that's only modestly transformative. And that's kind of an interesting phrase, right? It's not transformative, it's not an on-off, either it is or it isn't. It has degrees, at least according to the Copyright Office, and it says that's modestly transformative. By comparison, right, AI systems could be used for far more transformative purposes that probably makes them fair uses. So suppose we want to develop machine translation from one language to another, like Google Translate says way more transformative, right, in terms of having a different purpose than the original works it was trained on. Or maybe a computer application that corrects grammatical mistakes in writing, or it provides interactive foreign language instruction, or in another medium, it removes distortion from audio tracks and makes them more natural sounding. Or maybe it provides automated content moderation, determining which posts on a forum comply with the content rules of the forum and which don't, right? So it says, in comparison with those goals that are very transformative, creation of more content that could compete with existing content is less transformative. Not transformative at all, but less transformative than those others. The first fair use factor in Section 107 also mentions that nonprofit educational use will weigh in favor of fair use. And of course, the fair dealing exception also has an educational purpose component. But the report notes that that doesn't mean that all use for purposes of education is fair use, right? You may be able to copy excerpts of works for educational purposes, but suppose that you wanted to create a new library. And so you said to an existing library, can we copy every book in your library to furnish our university library with all your books, right? Wouldn't count as fair use, at least probably not under US law. My guess is not under Indian copyright law either. So more broadly, I think the point is that um, to say that generative AI training is just like human learning or human reading doesn't make it fair use. Not all use for human learning is fair use. And generative AI is unlike human learning or reading in a number of aspects. And here I'm kind of proud to say the report happens to cite and quote an article that I wrote called Copyright and the Training of Human Authors in Generative Machines. It's available on SSRN if you want to take a look at it, in which I say, among other things, that the distinctions between reproduction rights and display or performance rights depend on human limitations. They rest on human limitations, and to the extent that computer algorithms far exceed those or surpass those limitations, to the extent that a computer, for example, can process 5 billion images in a couple of months, whereas it would take us far more than a lifetime to learn from those images, that kind of goes beyond the entire structure of the exclusive rights. Um, so that's kind of transformativeness. The report notes that most generative AI training these days is being done for commercial gain. That weighs against fair use. Um, and then, I want to jump sort of the second fair use factor, which is the purpose and character of the work, because the report recognized that lots of different kinds of works can be the subject and are the subject of training. And most of them are published, at least in the sense that they were posted on the internet. So the third factor is the amount and substantiality of the portion copied of the work. And of course, whole works are being copied. That sounds like the amount is great. There has been an argument that those works really aren't being, the expressive parts of those works aren't being copied. And this is merely a intermediate copying that is resulting in eventually in a new work. So it shouldn't count, even though you are technically copying the whole works. And the Copyright Office, I think, sort of pushes back against that a little and suggests that the concept of intermediate copying in US fair use law has really been mostly limited to a computer code context, and to a context that involves antitrust concerns where companies are like seeking to tie the sale of a video console to all of the cartridges that could be used with that console. So it suggests that intermediate copying is not this broad principle that could be used generally. And then lastly, the fourth factor is harm to potential markets for or the value of the work. And here the Copyright Office comes out in favor of counting not only direct lost sales, but also what it calls market dilution as market harm under the fourth fair use factor. And I think that's going to be controversial. I think there are many people who think that market dilution shouldn't count as a kind of potential market harm under the fourth factor. So direct loss sales, right? Those are relatively uncontroversial as a form of market harm. So if I publish unauthorized excerpts from an autobiography, and that causes a newspaper which had entered into a license to publish some excerpts to back out of the licensing contract and fail to pay the licensing fees, then that lost licensing revenue will count as market harm. But what about the case in which the generative AI outputs are not substantially similar to any of the training works, but they compete in the same market as the training works? So suppose I train a model on detective novels, and then I use it to generate new detective novels. They're not substantially similar to the ones I trained the model on, but they do dilute the market for detective novels. Some people will buy the new ones instead of the ones that were used for training. Here, the Copyright Office concludes that should count as market harm. I'm sure there are plenty of academics, at least, who believe that shouldn't count as market harm. So that's going to be a controversial interpretation, I think, of the fourth factor. So that's my first kind of run through, and I'm happy to answer questions or engage in additional discussion.
Uh, Thank you so much, Robert. I'll come back to you specifically on this market sort of compensation part, because this sounds interesting to me. Because when you talk about competition, right? I mean, I do have a question. I will come back to. Now, before I do that, I go to Courtney. What are your thoughts on this issue? And specifically, if you'd like to discuss, how the cases in this specific area are sort of proceeding. I think our chat informs that there are more than 30 cases which are pending in the US. Right now, in the Indian context, I am only aware of this Delhi High Court, which is OpenAI versus ANI. But how are these case laws sort of proceeding? What is the possible approach which the courts might take, and what the findings of this report will have a sort of bearing on the court's decision making.
Thanks so much,
Over to you.
Samin. Thank you for the invitation to join this discussion, especially because I think that there's too much of a tendency to discuss the copyright issue and competition policy issues separately. And I think that we have, what's very important to acknowledge is that copyright is a critical part of structuring the market, and it will shape competition in ways that will ensure that certain sectors, whether journalism, the entertainment industry, the creative industries, individual creators, remain viable as sectors of the economy, as parts of economic growth, as, the cultural value provided by, different countries and cultures. And, before jumping into the cases, let me just set the scene by mentioning that, the major AI companies, the US, major companies, it's basically a US China race at this point, are set to collectively spend upwards of $1 trillion on AI development over the next 5 years, with the only input that they are not currently required to pay for is data. So they have to pay for the chips, the energy, the water, the space, the human resources, all of that. But they've tried to decide that data, which is a critical and transformative part of the generative AI value chain, right? It really is the combination of increased compute and vast amounts of data that have given rise to generative AI. And so it's important not to look at these issues in a vacuum, and to acknowledge that these companies have purposely exploited loopholes and gray areas in copyright law in an attempt to make these unprecedented profits before the law catches up with them. And this is very much the playbook that we've seen throughout the big tech economy, whether we're talking about, Google, Meta, and privacy, whether we're talking about, Uber and Airbnb and their approach to, just ignoring regulations. So we have to acknowledge that. And I think we also need to acknowledge that we're not only talking about what the result of copyright is going to mean for a handful of big tech companies. It's going to affect the entire industry and the entire economy, because the AI copyright debate often overlooks the fact that many businesses are both AI developers and content creators or publishers. And so we need a long-term solution that benefits both sides. So it was great to hear Robert's discussion of the Copyright Office's report, which has actually now been submitted into evidence in the New York Times case, and most likely others as well. And so there are more than 40 copyright cases against AI companies that have been filed since 2022. They span multiple jurisdictions and legal theories from most of them, the vast majority are in the US. However, there is also one in Canada and France, India, as you mentioned. And there is a case before the European Court of Justice as we speak that was brought by Hungarian news publishers against OpenAI. And that will be really interesting to see how that comes down. I think we're expecting a decision any day now. So what we know in terms of the types of legal actions is the vast majority of them are claiming copyright infringement. So, this is the New York Times versus OpenAI and Microsoft, the Getty Images versus Stability for training data. There's a case against Perplexity for RAG data. And I want to just stop here because when we're talking about copyright for inputs, as they relate to outputs, of course, you have to think about both the training data, which happens at multiple stages, and you can have multiple rounds of training, and that kind of creates this base model. But then for a lot of the applications that we're using in our kind of daily life, whether you're talking about a generative search product or a chat bot where you're asking it questions or having a discussion about something in the world that's happening today, it needs to update what you can kind of think of as a relatively static model with more relevant, timely information. And it does that through grounding, a process called retrieval augmented generation, which essentially goes out onto the internet or into a specified body of data and content that you've given it and returns results based on that. And so we see, for example, that really impacts the news industry because, if you are Perplexity and you're trying to provide answers about anything that needs to be factual, relevant, timely, then you're going to need access to news sources. And so that is why we see a lot of these cases happening. So we're seeing both training data cases, RAG cases, the training, both in terms of the logistics, the actual technicalities of how AI models are developed, and that actually involves creating copies. And so, in a review that the Center for Journalism and Liberty did of several different countries and their copyright laws, most of them prevent full-scale copying of copyright protected works without permission. And many of them, as Robert kind of alluded to, do include a fair dealing or fair use, research exception, but not for full-scale copying and not for commercial purposes. So some of these are looking at that, we'll have to look at the specific technicalities, and there will be there's going to be a debate over that. We don't know how the courts are going to come down on this, but now, of course, they have the Copyright Office report to base it on. I think the core legal question in the case at the Court of Justice is whether the training and functioning of an LLM, a large language model, and the responses it produces can amount to acts of reproduction or communication to the public under EU copyright law. And this is by far the most significant copyright case. So there's also a case in Canada where a dozen news organizations have sued a Canadian AI startup because they found evidence that it is copying publisher content even when it's behind a paywall or when a website has communicated its preferences to block bots from scraping. And so that's really important because some of the arguments here you hear in both in the court as well as in policymaking is, okay, well, we'll have an opt-out, right? So give rights holders the ability to opt out. The problem with an opt-out approach is it is the opposite of how copyright has worked for, over 200 years. And second, it places the burden on the rights holder rather than the entity that wants to use that information, which transfers, the burden, human resources, costs, et cetera, to that party. Third, there are over 1,300 AI scraping bots out there. How do you keep up to date with them? How do you know that you have the latest research on that? There are companies like Cloudflare and I think it's called Dark Patterns or Dark Secrets that keep lists of these and try to keep it updated. Of course, those are largely paid services. So again, should rights holders be required to, bear the cost of opting out? And furthermore, you can't necessarily opt out of all the scraping or even specific scraping. And in the case of Google or others, it could mean that opting out of one form of scraping. So say you just don't want to show up in generative, in Gemini, for example, in their generative chatbot, and you opt out, you can get essentially penalized and not show up in search, which means your site basically doesn't exist, given that Google holds an illegal monopoly in search, according to the recent Department of Justice finding. And of course, I mean, pretty much every other competition authority in the world has found the same thing. So then that's not even a viable option, right? Furthermore, the idea is, okay, well, communicate your opt-out preferences. You do that either in machine readable format in robots.txt, which does not really have the ability to communicate an array of preferences or different types of licensing agreements, and it's voluntary. And we know there is evidence that these companies are intentionally bypassing these voluntary these voluntary descriptions of what can and cannot be done, that they are bypassing paywalls. Furthermore, how we decide this, one of the most amazing gifts that humanity has created, not gifts, but like technologies that we've created in the past, 50 years at least, is the internet. It's one of the greatest things we've ever done. The open internet, this free flow of information, anyone can build on it. How we are dealing with this question has profound ramifications for the future of the open internet. Because if you can't put your content out there and say, hey, I want to, put the news out there and maybe someone will subscribe. I want to post my song or my monologue in hopes that someone will come buy a ticket to my show. If you don't have that exchange of value potential, then it's not going to be economically viable for the information or the creative industries to continue. And it means that more and more creators will put their content behind paywalls or require subscriptions. And this is very dangerous for two reasons. One, it will reduce, the information online. It will turn information into a luxury good that only those who can pay for it can afford, or, same with entertainment. And it will, it will just create the conditions where the first movers in AI development will have an anti-competitive advantage because they were able to essentially crawl and scrape all the content of the internet that was mainly human generated. I mean, there was still a lot of junk, but like not nearly as much as there is now. So I think those all have to factor in. And as we're waiting for these cases to kind of play out, I would just highlight a couple of other aspects. So in the US, we have the Digital Millennium Copyright Act, which prohibits kind of the tampering with the digital rights management. And so there are a couple of cases around that. That does not seem to be a very effective argument so far based on some of the initial rulings. There are also some cases around contract breaches. So, you have a terms of service as a, creation website as a publisher, and then they're violating that, right? Most news organizations, most creative content has some sort of restrictions on usage that they have bypassed. And there's also the issues of like trademark and rights of publicity, which is slightly different than copyright, but is also showing up in a couple of these cases. And just before I wrap up, I would note that there was one important decision in the Thomson Reuters versus Ross Intelligence case, which actually started before ChatGPT was launched. And the court rejected the fair use defense for training data. This was not directly generative AI related, but it did address the important precedent for the work of, making material available. It is copyrightable. There is a, decision is pending appeal, but I think that a lot of people are looking at that. They're looking at the Warhol case, which was the case where someone created what was essentially an NFT, so this digital replica of something, and sold it, saying that was something different, and the court said no, that is not fair use. I think it's very unclear how the legal precedent will apply because the scale and scope is so different. The amount of money we're talking about, and I would just add to this wasn't in the Copyright Office report, but this question around the market, not just market replacement, direct or indirect, but also these companies, if we continue kind of to allow theft as a model of business, then that provides an anti-competitive advantage to companies like Microsoft and Google that can afford to indemnify their clients. They have offered indemnity to any clients using their products if they get sued for copyright. Most companies cannot afford to do that. And it means that we're actually, precluding the creation of a market for AI content licensing, or at least we're stilting it, because why would you pay to obtain content if you can just take it for free?
Courtney, are you done with your comments?
Yes.
Yeah, great. Gauri, I come to you. There are mostly two broad areas which I would like you to touch upon. First, of course, what is the core difference between US copyright law versus Indian copyright law? And the second thing, I think Robert and Courtney have already touched upon it, but how is sort of Indian government approaching it in terms of, there are of course these big tech companies, right? But there are also small tech companies in India,
Yeah.
right? I think just 2 days back, there was a readiness assessment methodology conversation which happened hosted by UNESCO and the MeitY, Ministry of Electronics. So I think apparently 4 Indian companies are also currently right now working on foundation models,
Yeah.
right? So first, what is the core difference? Because we have heard mostly about the US side. So what is the position under Indian copyright law? And second, what is the likely policy of the Indian government? Because of course, the government is also continuously wanting these tech companies to make investments. Both the panelists have touched upon competition, right? So there's a draft competition bill which was introduced last year, but now it has been put into shelf. So, what are your thoughts on it?
Sure. So, what I'll do is I'll give an overall outline, where things stand today, and then I'll answer your first question if you don't mind, because, I mean, I really thank Robert and Courtney to, sort of lay the groundwork, on various aspects. I really, enjoyed listening to them, and most of those issues, sort of apply in the Indian context as well. But just quick background on 2, 3 different developments that we have seen. uh, Earlier this year we had MeitY, subcommittee paper on AI generally on multiple topics, and one of the topics that they dealt with was also on the copyright, right? So they raised two questions. Of course, the authorship and ownership of the work generated through the use of AI, and the second one, of course, is on the infringement. And they have given some perspective on should there be compulsory licensing, what should be the balancing element between the copyright owners and the the developers of the models, etc., right? So you can see that the questions raised, sometimes you have to read into the thought process, right? So you can see that the questions raised are sort of alluding whether there should be some balance. So I'm not saying that that is the view of the government, but because if you see a couple of years back when this entire AI theme started, if I remember correctly, the Indian government had made a statement that the current copyright law is sufficient to deal with the situation, right? That was the initial thought process. But if you see, there has been somewhat a shift to revisit, what does it mean, right? I think even in the context of ownership, or whether it should be the the model generated work is entitled to copyright. I think the same issues that Robert mentioned in terms of how much creativity, etc., those principles will remain the same in the Indian context, and MeitY is also asking those questions. Now, in the meantime, we have this ANI case started, last November or so, and we have seen the arguments, on both sides, and the arguments still continue. Before I deal with some of the elements that are being discussed there, I want to just clarify. I don't know about other jurisdictions in terms of speed of the outcome, right? In terms of the judgments. In the Indian context, what we are really looking at whether there should be an interim injunction or not. So we are not looking at the final determination of the issue, though the questions raised before the court do specifically say that does storage amount for the purpose of trading amount to infringement. There are four questions, right? Does it amount to infringement? Will the use of the copyrighted work for the purpose of generating, through the AI the output through the AI, will that amount to infringement, right? Is there a defense available of fair use under Section 52 or not? And the last but not the least, on the jurisdiction, which is a very peculiar, question in the Indian context, that if the storage, training, and everything has happened, at least with respect to OpenAI, it has happened outside the country, does the Indian court even have the jurisdiction to deal with this, right? Because probably the infringement at all, if any, has happened outside, and there are arguments for and against, on both counts. Interestingly, the Indian court appointed what we call as amicus curiae, a friend to the court, two distinguished professionals, one a professor and another professional, right? And they have given their perspective. Now, if you see, even when they are giving their perspective, sometimes, in the Indian context specifically, I want to draw an analogy, right? When we I may be slightly digressing, but very interesting point, to look at sometimes how the Indian courts think, especially at the time of interim injunction, right? When we looked at pharma patents, right, infringement or not, in some situations courts have, of course, at the interim stage, sort of looked at what is public interest, right? If the injunction is granted at this stage, how will, the public interest may be affected, right? Because you have still not decided, because patent, whether infringed or not, needs a very detailed determination of evidence, etc., etc. And only on the prima facie basis can you really grant an injunction when the public interest is likely to get affected. Why am I saying this? Because even in this context, it is very simple to frame that, okay, there is storage, and then there is there is training, and then there is output. But as Robert beautifully pointed out, there are various facets in terms of, how the training happens, what is the purpose for which the, output is going to get used. Just to give an example, in the pharma, in the diagnostic field, right? If I'm using various X-ray images to train AI, right, and then, the output is really the diagnosis of the new images that are, sort of put into question to the AI model, right? So the use cases will be completely different. So therefore, I wonder, when the court is looking at it, whether the court will look at only in the context of content, as Robert, put the difference between the use cases, generation of the content which is in competition or likely to be in competition with the input content, or is the, is the determination going to be so wide? Because if you see, the question framed can be, used in multiple situations, right? I'm keeping the transformative part a little aside for the time being, and there is a reason for that. I'll come to that in a bit. But what I'm trying to say is that the interim order may have a far-reaching consequences overall, right? And in that interim order discussion, if you see, multiple parties have intervened. And the reason I again bring this up, because various stakeholders are in front of the court now and trying to intervene into that matter. And some of them, and I'm saying this, Sumit, because you pointed out, the startup, in the Indian context, startups, how the government is looking at policy and all that. And there, some of the startup have intervened as well to say, that we will be affected, right? So how will, then there is some think tank who has intervened. So there will be multiple elements or stakeholders arguing before the court. And what are they arguing for? Whether the interim injunction should be granted or not. Now,
True.
interestingly, insofar as ANI specifically is concerned, they have already opted out at the point that Courtney raised, right? So will the court look at, okay, if they have opted out, now the AI has been already trained on the past data, right? So whether I grant injunction or not vis-a-vis ANI doesn't matter, because now going forward, they have opted out. So only the case remains now for probably damages, if any. If the court takes that view, you will not have any determination on the legal issues that, that have been raised. So
True.
the reason I'm pointing this out is, we cannot rely so much probably on the ANI case determination as to how the country may move forward in this context, because all the points that even Courtney, competition, all the other points Robert raised on end uses, all of that. And that probably is a trigger. I don't know what is the trigger, but therefore now what is happening is DPIIT, which is, the Department of promotion, those who are not aware, but there is a specific department of promotion of industry and internal trade. Now if you see the what is the purpose of the department is promotion of industry and internal trade, right? And they have now formed a committee which has government, of course, government members. Then you have members from NASCOM, which is a government, an industry representative body, which is largely represents IT industry. Then you have two practitioners and one professor. Now, when you see the composition of this committee and the four questions that have been put before the committee are futuristic. So one thing is to see, all the arguments that Robert and Courtney mentioned insofar as the infringement, no infringement, all of that, of course, is for the existing law, correct? Of the interpretation of the existing law. But what the committee's role is, in my view, and irrespective of the ANI outcome, the committee's role would be what should be the right thing for the country to going forward. Now, if you see even in so even in the ANI case, if you see two amicus curiae have taken very two distinct approaches. One is saying, please look at the policy angle while determining the interim injunction. Other is saying, don't do that, go by the strict interpretation of the law. So there also, before the court also two competing approaches, are being debated. Right now, coming to the four questions, really, before the DPIIT, it says identify and analyze legal and policy issues. So let us look at that, as a policy issue. And there you have seen in the Indian context, right? The IT industry has been at the forefront in terms of export of services. Right now, the country is looking at, make in India, develop, as you rightly said, foundational models in India and all of that. So I think somewhere the committee will have to look at what is, forget, the existing Copyright Act for the time being, right? But the committee will look at what, if at all the country has a certain vision vis-a-vis AI, what should be the right policy. I mean, maybe completely arbitrary, in the traditional concept of copyright law, the way copyright law has developed, but there may be some debate probably on what should be the right way forward vis-a-vis this. Just to give an example, when I have been in some panel discussions, compulsory license. Now, but so many follow-up question arises: who determines the royalty? How the royalty will be determined? What type of use, right? Is it transformative, non-transformative? So all those questions. So it's not like one size fit model possibly, right? So that is, of course, on the training aspect. But I'm sure they will also debate on the point that Robert mentioned on the ownership and the authorship aspect, right? Authorship and ownership, and that has yet not been debated enough. But whoever I've spoken to, and in fact, I sometimes I do more like when I go to colleges, I want to see how the students are thinking about this, because they are the ones who are going to take this industry forward, right? So students also, I can see the reaction saying that if the machine is doing everything, then you should not really own it. I mean, I'm just giving a feedback, right? So but how do you determine how much is good enough, right? Those thresholds. So all of that, I think the DPIIT committee will look at. So what I understand, that as per the reference given to them, they will come out with a report, their initial reaction, and thereafter we will we probably can give inputs. As Robert says, maybe thousands of inputs may be given to the government. We'll need to see how. Now, coming to your specific question, the first question you asked, at least my reading, I mean, my personal view of Indian fair use is definitely narrower than the US, if you really go by the strict interpretation in terms of Section 52. But there have been some cases which have also relied upon the four pronged test that the US law has given, including whether the output is competitive and all of that, transformative, competitive, all those principles, right? But in the ANI case, again, one of the amicus, and I think it was also argued before the court, that while some of the precedents may have looked at the US law and applied that in certain cases, if you go by the strict interpretation of our Indian law, the Section 52 is very, very narrow, right? It's a private use, and one of the amicus argued that private use should be interpreted in a manner that the machine is learning in on its own, right? I mean, some ingenious arguments were being put forward, right, in this context. So that's a quick summary of where we are today. So I don't believe that ANI case it's end of all. We will need to see at the interim level what happens. The court, it is very easy for the court to take a very simpler approach. There have been interventions also, sorry, I should have mentioned this before, by the music industry and all of that as well, because different industries may have different kind of issues coming up in terms of even competitiveness and all the other points that Courtney and Robert mentioned. So whether the court is going to look at all of that or limit their their case vis-a-vis only ANI, we'll need to wait and watch. But DPIIT is something, I'm really sort of keen to see, how they react, more on the policy side, or, strictly by the law side. We will need to wait and watch. But in my view, overall, there has to be some balancing approach between the right owners and the use cases, right? But how that balance, sort of ultimately lands up is something. I'm not saying, again, giving my personal view, but I'm saying that there is a possibility that the committee is looking at a balancing approach, rather than sort of as Robert was saying, tilting only towards the owners or otherwise. So let's see. But this is a quick background on. I know I've taken longer, but there are multiple facets which I thought I'll just bring to the table.
Yeah, thank you so much, Gauri. I think I have my own thoughts in terms of what would be the possible limitations of the DPIT panel. And the reason I say that is because MCA last year formed a panel on the DCB, right? Interestingly, the panel supported. The panel came up with a long report. They came up with a draft bill also, right? But the fact that law is still in hanging, I have my own reservation, even on the committee recommendations, regardless of which side they go. So that being said, now I again go back to Robert, and I'm really sorry, in the interest of time, we are already at 7:47. If the panelists can keep their remarks short. Robert, I mean, from a public policy standpoint, the way at least I see it as, the first question is, of course, there is a lot of, I mean, if hype, I may not, if for the lack of a better word, there is a lot of hype around there, right? That, it is there to transform the world. There are a lot of use cases, be it in the medical sector, be it in the health sector, and so on and so forth, right? What we in competition law, what we call is the quote unquote efficiency defense, right? So now on one hand, we have this entire, productivity aspects, this efficiency aspect when it comes to big tech, when it comes to AI. But on the other hand, which the third part of the report very correctly points out, that, at the end of the day, these people who are basically artists, people who are actually having these copyright claims, right? The fact that their sort of rights are being infringed left, right, and center. And very interestingly, because competition is something which is continuously coming up and again in this panel discussion. Very interestingly, in a lot of US cases, even in the edtech case, right? One of the remedies which DOJ applied was for a specific harm. And some of you would have gone through the judgment. The first thing which Google did was it came up with a check, right? So I sort of see that approach missing in the copyright law, because I can tell you from an antitrust perspective, from a competition law perspective, money is not a problem for big tech, right? There are this edtech case is a recent one where the first thing which they come up with is a check, that you don't have to worry about money, but you make sure that our monopoly is basically preserved. So this being said, Robert, what are your thoughts in terms of course, we fundamentally would differ what is happening in the US and what is happening in the India, right? And this difference is, of course, very much visible in how we see technology also, right? Because I think the US president is currently proposing a big billion, some big, beautiful bill, something like that, right? Where he's proposing that, there would be no laws and policies applicable on artificial intelligence. Now, of course, India is fundamentally different from that. But Robert, what are your views in terms of ensuring this hypothetical quote unquote balance, which Gauri pointed out? Because at the end of the day, fortunately or unfortunately, every public policy is about maintaining a balance. So, what are your thoughts on this, if at all some intervention has to be made?
Well, I mean, in the broadest sense, I do agree that copyright does involve balancing. Obviously, if we gave the first person ever to write a detective story the exclusive rights to the entire genre, we would think of that as anti-competitive. But if we allowed copying of each story that that person wrote indiscriminately, that would remove the incentive to write those stories. That would also be anti-competitive in the sense that it wouldn't give enough incentive to create the content in the first place. So that's important. And I think from a policy perspective, one of the questions has to be if the generative AI companies provide no compensation or credit or control to the existing human authors of the works that are being used for training, is that going to diminish their incentive to create those works, or their ability to create those works in a way that we have to be worried about? Now, I happen to think that it will, but obviously, more study would have to be done about that incentive side. I do think you've mentioned at several points international competition, and that raises a whole different kind of game theory aspect. It's one thing if you could control the law for the entire ecosystem of content creation. How would you set the balance? It's another thing if you have multiple jurisdictions that are all trying to set this balance, and maybe there is some advantage for one jurisdiction to be lax as long as all the other jurisdictions are enforcing the rules, right? That's this kind of classic game theory situation where, sure, if one jurisdiction allowed AI training and everyone else was being protected in all the other jurisdictions, that might work out fine for that one jurisdiction. So we have that kind of race to the bottom aspect in international situations. That'll partly depend, the quality of the race to the bottom will partly depend upon this very interesting jurisdictional issue of if the training is done outside of India or outside any particular jurisdiction where you're adjudicating the action. Do these companies still have a cause of action in the country where the system is being deployed and used? Right? That will have a very interesting outcome on the whole game theory aspect of this. Eventually, I think, of course, treaties are a fix to the problem of race to the bottom, and we already have copyright treaties in the Berne Convention, and in TRIPS. And eventually, it may take 20 or 30 years. Eventually, I could imagine an international treaty developing if AI becomes so important.
Can I just respond
Yeah.
with respect to a couple of things? Because the idea of balancing was mentioned a couple of times, and I think that is part of it. But if you look at the US, the copyright clause of the US Constitution, it states that the purpose of copyright law is to ensure that copyright protections advance the public interest. So it's actually not a seesaw, right, between the rights holders and the AI companies, because that then fails to account for the public interest. And so when you're thinking of public interest, we need to take it out of this narrow concept of the seesaw, balance, because you need to think about, as was alluded to earlier, what is this going to do to the labor markets that produce expressive and informational content? And, there is a fundamental difference between the sector specific type of AI for, in medical science, hard science research, people, um, people who do not like the idea of copyright love to cite the the advances in learning about protein folding, which was really challenging. But that did not come from indiscriminate and uncompensated scraping of data. That came from from obtaining authorized access to scientific papers and spending a lot of time going through that data set and making sure it was quality. So we need to, I think, differentiate between these things. And we need to consider, as I mentioned earlier, what will this do to the broader information ecosystem? What will it do to the market, the information markets, right? How will this affect market dynamics? How will it affect the labor market? And Gauri mentioned earlier, like looking at kind of what is the value that and what will this do for the AI sector. I think it's very important to look at what the UK has done, because the publishing and creative industries have gotten together and said, like, look, we have empirical evidence and a history of creating, I don't remember the number off the top of my head, but it's billions of dollars of economic value. Over here, you have kind of this theoretical idea, these projections largely by firms that stand to make a lot of money if this version of AI continues, that are saying, oh, it's going to create all of this economic value. But we don't actually have a lot of evidence of that yet. What we do have evidence of is, the type of products that are, in many cases, kind of at the root of a lot of these copyright cases. Chatbots, these kind of, generative search, information retrieval. We know that they are error prone. The industry likes to use the term hallucination, which is a anthropomorphic term for what is error. It is error ridden, and yet they have released it to the public. In many cases, those errors are dangerous and unsafe. And yet, in the rush to, lead the AI gold rush and make the most money as fast as possible and set the rules of the game that everyone else is going to play by, they have disregarded their own internal research, recognition by the leading AI scientists and experts that these products were not safe and not ready for prime time. They're doing it anyways because of this innovation race. And yet, what are we talking about when we're talking about innovation? Are we innovating to put humans out of existence, to put to put our creative, expressive industries and sectors, just to eradicate them? Are we talking about getting rid of journalism because it's already unsustainable? And then, by extension, the destruction of democracy? Like, this has to be part of the discussion when we're talking about copyright and how to decide this, because fundamentally copyright is about the public interest as you're deciding how to figure out where these rights lie, what the right balance with, research and satire or whatever is. And I think that that is very important and often missing from a lot of the discussion. And so, I'm glad we're able to hear.
Yeah. Thank you so much, Courtney. Gauri, your concluding thoughts.
Sure.
Unfortunately, we are
Yeah,
almost done, but yeah,
but
I
I
would.
think, I will be very brief. I think echo what Courtney said, and that's what I feel sometimes. When we try to separate out, one issue, harm, versus copyright versus something else. Uh, are we doing justice to the subject? I mean, I'm also sort of still digesting this particular element, that can we look at copyright issue in isolation, or should we look at holistically in the context, that Courtney said, right? Because one can have effect over the other. Just to give an example, in the US, you saw writers community coming together, right? To the point that Courtney mentioned, that writers community coming together, saying, in what context can you or can you not use, AI for the, because otherwise the writers community can get replaced, right? So ultimately, there you can have all the possible technology out there, but what are the guardrails under which, one can sort of take it forward? Because sometimes what happens in technology, it evolves without guardrails, then suddenly you believe that okay, something needs to be done, and then those who have already evolved without guardrails sometimes get an advantage over the others who are coming in the race later on, right? So when you look at that, again, I believe there is a balance between the past and the present. And then when you are putting the guardrails, what are the real harms holistically? Can you really separate one from the other, as I said, right? And then holistically look at it, because if you are allowing copyright, for example, to be given to the work generated through the AI, then companies would be more than happy to replace them with the labor, the artist. If you don't give that copyright, right, there may be, then for them to keep that leverage, it may get difficult, right? So what are those elements which will have an impact one over the other has to be looked at holistically before we move forward. But I think some guardrails will evolve over a period of time. At least that's what I can see around, on this point.
Yeah. Yeah, thank you so much, Gauri. I think we have been barely able to scratch the surface. I understand there is a lot to actually uncover, and we are also actually following what is happening in the world of artificial intelligence. But certainly, this conversation is helpful. This conversation it has been live streamed on YouTube, so we'll of course it is available. It would be available in public domain. Uh, I myself have sort of learned how does sort of public interest play into this entire sort of debate. As far as the conversation on competition is concerned, that's of specific interest to me, because when Robert and I think Gauri also pointed out that you are allowed to basically file for damages, but if there is some sort of notional loss. For instance, if I sort of train my data on a certain area and I come up with a product which is competing with the players which are already in that area, right? So would the idea of compensation be applicable or not? So I think that's a very interesting question from the point of competition law as well, right? Courtney, I think, correctly pointed out that what we call as India, quote unquote, whole of government approach, right? That there is no point in seeing competition law in silo, copyright law in silos, data protection laws in silos. Possibly it's high time that there is a concrete and there is a coherent policy by the government where they sort of put the guardrails very clear and ensure that this technological growth and economic growth happens in a just and sustainable manner. So I think this conversation was really helpful. We would be making a representation to the Indian government, which is the DPIIT, on the basis of understanding which we have developed. And thank you so much, Robert. Thank you so much, Courtney. Thank you so much, Gauri, for agreeing to be a part of this panel and giving your valuable time to discuss on a very important area of law, which is law and technology, both which is emerging right now. Of course, we'll be in touch and we'll be keeping, sort of ourselves updated, how this sort of conversation takes place. Thank you so much again.
Thank you for
Yes,
inviting
Sumi,
me.
thank you so much for the invitation.
Yep.
Thank you.
Thank you.